For years, I've spent a good portion of my intake sessions really the first chance to get to meet someone, first chance to get first impressions, gather as much information as I can, get off on the right foot. I've spent a good portion of that explaining privacy rights. Historically, that's because I happened to be in school at a time when this new law came out, HIPAA, and I think a little bit of panic set in, and we decided we have to explain everything to the fullest. Historically, also, it was a different time. The word app didn't exist. Now, you'll go through a privacy agreement, click on one a couple of times a week. At the time, the notices were out there, but the expectation was that we really need to explain those things. Pragmatically, I discuss privacy rights because it's important that you understand your rights. Unlike, say, Facebook, for example, I can't strong-arm you into agreeing with something. Hey, either click on agreeing to the privacy policy or you don't get to see pictures of cats in your nephew's graduation. Instead, I'm a real person, I encourage that discussion. So I want to have that ongoing discussion. So the federal law, Health Insurance Portability and Accountability Act, state law, the Minnesota Data Practices Act, as well as several ethical policies that I need to follow, all demand that I share your privacy information with you, explain it to you, and I do so. I provide a packet. If you were starting with me, you would read this packet, please do so. What I'm saying here today is supplemental to that packet. What is protected health information? Any information that you share with me, mention in session, fill out a form ahead of time, forms that I fill out for the betterment of your services to you, necessary for treatment, all that is protected information. This information is kept secured. That means double locked in my office or password protected on my computer or data encrypted on an electronic health records system. And actually there's been an addition to the HIPAA law in October of 2013. The High-Tech Act came about, and that was just an addition that there's been this big move for clinics and medical care facilities to move to electronic health records. I'm not a computer programmer, none of them are, so we hire on a third party to do that. It's cloud-based, and of course there need to be laws to protect your privacy on the cloud, and hence High-Tech was born. A nice little addition to that that was given was that all third parties, at least the way that I read it, all third parties that I work with are responsible for maintaining your privacy as well, which is a great thing because say you have to write me a little $5 copay and then you have a check that Wells Fargo has with your address on it, they're responsible for maintaining your privacy also. They have their own standards. If you want to find out about all my third parties that I work with and their privacy policies, you can find them all online, and I'd be glad to tell you about all the zillions that I work with, but understand that they're responsible for maintaining your privacy as well. Okay, locked and secured. It's all secured, right? That includes what's within me. I keep it secured. If we run into each other in public and you're my client, I'm going to do that weird aloof thing like I don't know you. And it's funny, for as many years as I've been doing it, it just happened a few weeks ago, and it felt rude on my behalf that I wouldn't go over to this family that I saw at a restaurant, and yet that is me maintaining your privacy. And so understand, it's just that I'm maintaining your privacy, and you have the right to do with your information as you choose. So you can come say hi to me, just as you always have the right to do with your information as you choose, even though sometimes it's not prescribed. I do not advise, for example, that you get really dramatic on Facebook or Twitter and share all your personal information with people. But again, that's your choice to do so. Again, absolute, all locked and secured, right? So here are the exceptions. Written signed authorization. If you sign off on me talking to someone, then I talk to somebody. Or at least I have permission to do so. I can't before you do it. First thing that we do when we meet, and I have you sign off a couple of things, like you understand this privacy stuff. I also have you sign off, if we're billing your insurance, that it's okay for me to talk to your insurance. Also, if there's anyone else that you want me talking to, your physician, your psychiatrist, somebody that prescribes medications, a social worker, a school social worker, probation officer, lawyer, a significant family member that has no legal right to you, again, I need that signed off. I've got the forms. We can sign that off in a moment. There's also vague disclosure of your information that I consult with a group of colleagues that I really trust. It's important, and I'm sure if you think about it for a little bit, it's important that I consult with my colleagues, that we share ideas, and we all become better together. It's the best service for you. We're not sharing any identifying information with each other. Anything that could hint them at who you are, that doesn't get shared. Other disclosures without your consent. If you are threatening to harm yourself or somebody else, I need to protect that person. Hey, people get low, you have hard times, and some people just wish they were dead or just wish they weren't here. It's not my job to run off and get an ambulance at that moment. I want to help you through that. But if I think you're going to walk out of here and you're not going to make it, then damn right, I'm going to do everything I can to protect you. Same thing if you're threatening to harm someone else. Your neighbor's pissing you off, I understand. And you say you just want to kill him, I'm not calling the police. If you tell me you have specific plans to kill your neighbor, I am calling the police. These are cases where I'm legally obligated to protect somebody, as is if I suspect abuse or neglect of a child or a vulnerable adult. I have phone calls to make and reports to file to try to protect that child or vulnerable adult. For judicial and administrative proceedings, if you're in court for some reason and I get court ordered to testify, I need to testify. If a judge says I have to submit records, I have to submit records. For health oversight activities, what does that mean? I'm a licensed professional. A licensed professional means that there's a state board whose job it is to look out for your rights. If I'm doing something inappropriate or violating your rights, that's a good thing that there's a state board looking out for your rights, but in order for them to do that, they might need to look at my records. If you are in a workers' comp claim, my records might be subject to that. And finally, complaints or lawsuits. If you sue me, I have the right to try to protect myself, including using records to explain what went on. Oh, one more. Cases of public health. If you get bit in the zombie apocalypse, I have to call the CDC and tell them that you're a threat to public health. Your privacy is important to me. Much of what I've said qualifies privacy data, health information as some kind of commodity. The laws were passed, in fact, so that agencies, clinics, people, professionals can't take your information and sell it. That understanding misses the mark. You are sharing very personal information for personal reasons. We can't put a price on that. You share your information so I can help you, with the expectation that I will handle it responsibly. I will make every reasonable effort to honor the courage you show by sharing very personal things. Madam Toastmaster.